a partner at Wolstorf Rosenthal. I'm actually based in our New York office. We also have an office based in California, and so today's presentation is going to focus on the visa options for international medical graduates, and I'm really going to focus on people who are starting their career in the U.S. And are looking into going into residency or fellowships or research, and just really starting in the early point in one's career, going down the path of a medical career in the U.S. Just some initial housekeeping. If you have any questions, please do feel free to type it in and I'll address them at the end. You're also free to, or welcome to email or call me after this presentation, and I'm happy to discuss any issues or specific concerns that you may have. So today's discussion is just going to focus on the temporary work visas, or as we refer to them, non-immigrant visas for international medical graduates. I'm not going to talk about green cards. That's a whole other area, and we'll set that topic aside for a future presentation. I'll also talk about how to go about obtaining the non-immigrant status and some other issues or problems that could arise. Now, the most common work visa options for the physicians are the J1 and the H1B, which is what I'm going to focus on today. But just to mention a few other options, there is the O1 for people of extraordinary ability, and this one is really for someone who is a little bit further along in their career and can really say that they are truly at the top of a very specialized area of expertise. And you know, to qualify for an O1 within the sciences, we like to look at somebody's resume or CV to see how long or how many publications they've had, how often they've presented at international or national conferences, any other achievements or sustained achievements they've had in their field. So that is for the O1 for people of extraordinary ability. The TN is based on the Treaty NAFTA, and it's limited to Canadian and Mexican citizens. And for physicians, this is also further limited to only teaching and research. You would not actually be able to do clinical work on the TN. The E3 is also similar in that it's only for Australian citizens, but with the E3 you can actually do clinical work, but again it's just limited to Australians, and it's very similar to the H1B visa category. Okay, now just jumping into this, for the J1s, this is the most common visa option for people who are starting residency or graduate medical education. Very often hospitals will prefer that you do your residency on the J1 because it's much cheaper for them, and it is much more common, and you may not have a choice between a J1 or H1 when you're applying for residency, and you'll actually start with the J1. The process is that once you've matched into a program, you will receive your contract from the hospital, and then you have to apply for your J1 sponsorship through ECF&G. They're the only organization that will sponsor or support the J1 for graduate medical education. ECF&G, once they've received your application, including your USMLE Steps 1 and 2 and the Statement of Need from your country's Ministry of Health, will issue a document called the DS 2019. It's the actual J1 application or the approval that you will have to present when you're applying for your visa at a U.S. consulate. You don't need to have any additional approval from USCIS. The DS 2019 that's issued by ECF&G is sufficient. The one good thing about the J1s is that the spouse can obtain a J2 visa, and once you have the J2 visa, you can actually obtain an employment authorization card or a work card, which we refer to as an EAD. We've often seen couples where the principal applicant will be on a J1 doing research, their own residency, and the spouse starts his or her residency on the EAD as well. But just a word of caution is that timing can be pretty critical. If the J1's training completes, far in advance of the J2's training, there may not be a way to extend the work authorization, because what will happen is the J1 will then transition to an H1B, for example, as part of a waiver process, and the J2s wouldn't be able to continue the EAD and would have to switch to the H4, which is the derivative spouse visa, and that does not have employment authorization attached to it. And it may be possible to then switch that person to an H1B, but that can be really tricky in terms of timing. And as USCIS has also been a bit haphazard in terms of like whether or not they will grant the H1B to an H4 person who's hasn't had that 2-year residence requirement taken care of. Okay, some other issues that come up with the J1 is the 2-year home residence requirement. I will talk about this in further detail later on, but this is a main problem with the J1s, and the other issue is a 214B issue. This is really referring to the fact that when you're applying for a J1 visa at a U.S. consulate, you can't have any desire to live in the United States permanently. So if you have any green card processes started for you, for example, through a parent or a spouse, and but you're not, or even a sibling who's a U.S. citizen, but your green card process is, is going to take several years, you may not be able to get a J1 visa in the meantime because you've demonstrated that you want to live in the United States permanently, and that is in contradiction of the J1 visa. You also need to show that you have sufficient ties to your home country, that after you've completed your training, you are in fact going to go back to your home country and work there based on this knowledge that you gain in the United States. The J1 for residency is limited to 7 years. That's something to keep in mind if you want to go down a specialty that has, much longer track, such as surgery. So just keep in mind that it is limited to 7 years. They want to see progressive training. So if you, for example, have only matched into a prelim program for 1 year, and then you apply for the 2nd year and you get another prelim program, ECFMG may not give you or sponsor you or support you for that second J1 unless they know that you're actually progressing and that there's the likelihood that you will then match or continue on with your training into this PGY 3 or 4 after that. It is possible to get an 8th or a 9th year extension of your J1 if you can show that there's an exceptional need for that particular area of expertise in your home country. Another issue that comes up often is the timing issue. So the programs often start middle of June or beginning of July, and you will find out if you've matched sometime in the middle of March. And the likelihood is that if you're going through the J1 process, you're not going to get your DS 2019 until sometime maybe at the end of April. So you really only have about 6 weeks to obtain J1 status. If you're going home and you need to apply for a visa, please, try to book your appointment early enough so that if there are any administrative processings or security checks that are going to happen, you are giving yourself sufficient time for that clearance to, to go through and then your visa to be issued. If you would like to apply for a change of status within the United States, the application is an I-539 application, and that can take several months. There is no option for premium processing, which is where USCIS will adjudicate a case within 2 weeks. So that actually doesn't, there is no process for that within the I-539 process for J1 change of status. So that's just something to keep in mind for when you're acquiring J1 status. You can also get a J1 for research, and this might be, something that you would have in mind if you are going to be applying for residency, but you would like to spend 1 or 2 years in the United States doing research to bolster your candidacy for a residency program and having some publications on your CV. The J1 for research is instead of it being issued by ECFMG, this one's actually going to be issued by the university where you're going to be doing the research, and but it's possible that you may also become subject to the 2-year home residence requirement through research if your country of residency is on the skills list. And the skills list is basically a list of countries that the State Department has where they've recognized a certain shortage of skills. And if you're from a certain country where the area of medicine is considered to be in shortage, then just you coming to the United States to conduct research within will subject you to this 2-year home residence requirement. The other more common way of becoming subject is through government funding, either through the U.S. government, such as like a Fulbright, or through your home government. That is another way someone can become subject. It is possible then to also transition from the J1 for research into an H1B if you are not subject. So if you're from a country, let's say Canada, and you're doing J1 research and you don't have any government funding and Canada's not on the skills list, you can change status or acquire H1B status. And you can also transition to J1 from J1 research to J1 clinical if you can demonstrate the nexus between what you are doing your research on and the training that you're going to obtain through your residency program. Okay, for J1 physicians who they are the ones who go for graduate medical education will definitely become subject to that 2-year home residence requirement. And so now just a brief discussion of what to do when you are subject. So basically this means that if you are subject, you will see on your visa stamp from the consulate that there will be an annotation that you are subject to Section 212E. Often on your DS 2019 form, there is a question, an item at the bottom of the form that they'll also check that you are subject. This means that you cannot get a green card, an H visa, or an L visa until you've completed this 2-year residence requirement in the country that's listed on the DS 2019 form. The L visa is for intercompany transfers and actually doesn't really apply to physicians, but just so you know, more importantly, you can't get the green card or an H visa. And this is, remains to be true even if you're married to a U.S. citizen. If you are subject to this 2-year home residence requirement, you can't apply for that green card based on marriage to the citizen until you've complied with this 2-year home residence requirement. You can't change status within the United States. So if you have an approved petition, you can't request a change of status within the United States. You actually have to go to a U.S. consulate, get the new visa, and then come back in. You are, able to get other visa classifications such as the J2 for the spouse. You can get an O1 visa, all of these other visa categories, but you won't be able to get the green card or the H1B. And again, you wouldn't be able to change status within the U.S. You have to go get the visa stamp abroad, and then you can come back in on that classification. Just going back that, if you're not sure if you're a subject, definitely if you've gone through residency training in the U.S., you become subject, or if you've had any form of scholarships or government funding from your country's government or the U.S., you become subject, and then also if your country is listed on the skills list. Just also note that J2 spouses also become subject along with the J1 principal visa holder. Okay, now what to do if you are a subject. You can delay it by obtaining another visa classification such as an O1, and or you could go back home and spend the time, the 2 years, and then come back, or you could apply for a waiver of the 2-year home residence requirement. The 2 years that you're going to be spending in your home country can be an aggregate, so if you're going to try and delay this by coming in on an O visa, that's fine. And then just keep in mind that you can, plan to spend a couple of weeks or months every year in your home country, and eventually you'll, add up to those 24 months. And just be careful in how you document those exact days that you're spending in your home country, because once you've complied with that and you've got those requisite days in aggregate, you can then change status to the green card or apply for the H-1B. If you obtain citizenship in another country, such as you're from, let's say, India, and you become a citizen of Canada, you cannot fulfill this just by moving to Canada or to Dubai, for example. You actually have to show that you are spent the time in the country that's noted on your DS 2019. And again, you can do this in increments over several years. It doesn't have to be over one 2-year period. Okay, you can postpone it by obtaining another visa classification, but this isn't going to, you eventually do need to deal with this by either accumulating the time abroad or obtaining a waiver. Okay, waivers are mostly based on interested government agencies, and this is the most common way of dealing with the 2-year home residence requirement. The Conrad State 30 waiver is the most common of these IGA waivers. Every state in the U.S. has 30 slots for physicians who will commit to working in an underserved area for 3 years, and most of the states have set aside the bulk of their 30 slots for primary care physicians, and these are, also include pediatrics and OBGYN. The other specialists, depending on the state, sometimes they set them aside for the end, or they see how many slots are taken up over a period, and then they open it up to the specialists, or from the beginning they'll set aside maybe 5 for the specialists. And the more popular states receive more than 30 applications within the first month or 2 months that the program opens every year, and then the State Department of Health reviews the applications and decides what makes sense for their state and the needs of those communities, and then will recommend the waiver to this U.S. Department of State for this J1 waiver. Once the state Department of Health recommends it, it goes to the U.S. State Department, who then approves it, and then eventually will go to USCIS. Once you have this Conrad State 30 waiver granted, then you will have to apply for an H-1B visa and fulfill your 3-year obligation at this job site on the H-1B. The other common one is through the Veterans Administration, and then the next two, the Appalachian region and the Delta region, are based on certain states who fall within that region. You can also get waivers through HHS. They do have a special category for outstanding research, and this is very much similar to an O1 for people of extraordinary ability who are really doing cutting-edge research, are the principal investigators on like NIH grants, and can show that that their work is, that they're critical to this ongoing research. The other two waivers that are available are the hardship waivers and the persecution waivers. Hardship waivers are, for that you need to have an anchor relative, meaning a U.S. citizen or permanent resident child or spouse who would suffer exceptional hardship if you were to go home for 2 years, or they couldn't go back with you for 2 years, and can also stay back in the U.S. without you. Persecution is very similar to an asylum type claim, that you would fear persecution if you were to go home for 2 years. If you get either of these waivers through either hardship or persecution, just keep in mind that you can't actually change status in the United States once this waiver is granted. To then transition to an H-1B visa, for example, you do still need to go to a U.S. consulate, get your visa, and come back. Whereas if you get a Conrad waiver, you can change status within the United States. Okay, the next visa classification is the H-1B, and this is the most common work visa for all professionals. It's initially granted for 3 years, and there is a 6-year total. You can go beyond 6 years if a green card process is started, within maybe year 4 or 5, and then you can either get, 1-year extensions beyond that, or depending on your country of birth, you may even need to get 3-year extensions beyond the 6 years. The 6 years is an issue for people who have used up some of their H-1B time doing research prior to residency, so just keep that in mind if you are going to use up some H-1B time for research. Also, if you're going to go down those longer tracks, such as residency, and you want to do like cardiothoracic fellowship after that, that's a long road. It's an 8 or 9 year path, and you're going to run out of H-1B time. So if you know that, you should probably start off with the J-1 from the beginning, because you will need to set aside 3 years of H-1B time at the end when you're doing an IGA waiver, such as a Conrad waiver, because that can only be fulfilled in H-1B status, and you want to make sure that you have enough H-1B time at the end to do that. It is possible to get H-1B for residency. Most hospitals shy away from it because it is expensive, but one good thing about the H-1B for residency is that you don't become subject, but again, since it is limited to 6 years, if even if you want to do a fellowship after 3 years of internal medicine, you might still run out of H-1B time, because your training will be 6 years, and then when you want to start working in the United States, you won't have any H-1B time left. So that's timing is can be pretty critical. So just keep that in mind when you're applying for fellowship and thinking about what's going to happen after you're done with your training. Okay, H-1Bs can be filed up to 6 months before the start date, and you can apply with premium processing, so you can have a decision within 2 weeks of filing the petition. Otherwise, regular processing can take several months, especially at the Vermont Service Center. It is possible to change status from a J1 to an H-1B, but only for people who are doing those IGA waivers. Okay. Okay. The other issue with H-1Bs is that there is a limit to the number of H-1B visas that are given every year. The filing date is April 1, which is 6 months prior to the beginning of a fiscal year, which is October 1st. In addition to these 65,000, there are another 20,000 for people who have U.S. masters. But just so you have an idea of the 85,000 numbers, USCIS receives well over 200,000 within the first 5 days, and so the USCIS will conduct a lottery for H-1B numbers. If you're doing your residency on H-1B, you don't actually have to worry about the H-1B cap initially, because all teaching hospitals that are affiliated with medical schools are exempt from this H-1B cap, and they can apply for H-1Bs for their workers throughout the year. Also, if you are going to work directly for the medical center as a professor, for example, again, you don't have to worry about the H-1B cap. And if you're an IGA waiver physician on a Conrad, you're also cap exempt. But once you've finished your training, for example, at one of these teaching hospitals, when you have to apply for your, you want to go into private practice and transition your H-1B from the teaching hospital to private practice, your private practice employer is subject to the H-1B cap. And so that's just something to keep in mind, that they'll have to file for you 6 months prior in April for an October start date, and there's a possibility that if there's a lottery, your chance of being selected in that lottery are about 30%. So just something else to keep in mind with the H-1B visas. All of these work visas, and especially the H-1Bs, these are employer-specific. You need to have an employer who is going to offer you employment and file the petition for you. Physicians have to be paid a prevailing wage, and this can sometimes be tricky for people who are applying as a resident or a fellow, because their pay scale is based on a different scale, the ACGME scale, and not the standard scale for physicians in a metropolitan area. You do have to show that you have an MD or an equivalent, that you have the medical license in the state of intended employment. Most states don't have this license requirement if you're going through residency, but when you transition from residency to an attending position, you do need to have the medical license issued when you file for the H-1B. The other thing to keep in mind if you're going to use the H-1B for residency is that you also need your Step 3 for your U.S. MLEs completed. As you can see, H-1Bs are expensive. These are all the different filing fees, and so this is one of the reasons why hospitals tend to shy away from H-1Bs and would rather have you do your residency on the J-1. Okay, now just wanted to go over a little bit about changing status within the United States or going home to apply for your visa at the consulate, which we refer to as consular processing. A change of status means that you're in the United States and maintaining, lawful status. For example, you're here on a B1 as a visitor, and you want to have USCIS change your status to an H1 or a J1, and you don't want to go home. You can do that, but you have to show that there's going to be no gap from when your current tourist status will finish and when your future status will start. So if you come to the United States in, let's say, January, and you've been admitted until the end of June, and your program is going to start in the middle of June, then you should be able to file for a change of status within the U.S. because there would be no gap from when your I-94 is going to expire and when your program is going to start. But just keep in mind that if you do file for a change of status from a tourist visa admission within 1 or 2 months of entering the United States, there is a presumption that you had a different intent when you arrived, and that you might be hit with misrepresentation or visa fraud if you had this preconceived intent to stay in the United States and work when you came into the U.S. as a tourist. Another issue to keep in mind is that you could, when you apply for a future visa at a U.S. consulate, the consular officer may be upset with you that you had applied for a change of status within the U.S. instead of going home and getting the visa from them and coming back to the U.S. So just something to keep in mind for future visa applications. H-1Bs, you can request the change of status within the U.S. through this form I-129. It is a petition filed by your prospective employer. It's possible to request premium processing. Premium processing is where the USCIS will guarantee adjudication within 15 calendar days, but there's an additional filing fee of $1,225. It's possible that within those 15 calendar days they decide that they don't have all the information or they need more clarification, so they can issue you a request for evidence, and then after you respond to that they will give you the final decision within 15 days of receiving a response. The J1 is, for this one, it's a different application. It's the form I-539, and this is something that you as an applicant will submit to immigration. It's not done through your employer or the hospital. You'll file this I-539 along with the DS-2019 that's issued to you either by the university or ECFMG. You will also need to show as part of this application that you do have those ties to your home country and that you will, you do intend to go back after you've completed this program. There is no premium processing for an I-539, and it is possible that that this application can take several months, and you're not able to actually start on the J1 program until immigration has approved your change of status application and sends you the approval notice with the new I-94 attached to it. Consular processing is when you actually go to a U.S. consulate outside the United States, either in your home country. You can also apply at a consulate in a third country, as a third country national in Canada or Mexico, or you could go to one of the countries in the Caribbean. This is typically it's fine for when you've already had that visa issued from your home country and you're going for a visa renewal, such as you've had your J1 issued at your home country and now those are only given in 1-year increments and you want to renew your J1, you may be able to go to Canada for a visa renewal. But if this is going to be your first J1 or your first H1, it may those consulates in Canada or Mexico may say, well, you need to go back to your home country for this initial visa. Some issues to think about when you go to the consulate are these security checks, and the most common one is for men from predominantly Muslim countries, and they're often hit with this Condor visa security check, and this can delay the issuance of the visa by 2 or 3 weeks. The other one is the Visa Mantis. This one is based on the technology alert list, and we actually see this mostly affecting people from China or India, and you would have to show that you're not doing anything that's considered to be critical or highly sensitive, and that these are dual use applications. And again, this could delay the issuance of a visa by a few weeks. The donkey is the one that really takes a long time, and it can take several months, even a year or more, for USCI, for the FBI and the State Department and all the other organizations to agencies to confirm that you are not this supposed, bad person, and sometimes this can happen through a mismatch in the name, and the security check can drag on for a very long time. The other one is when you actually have a criminal conviction or an arrest in the U.S. or abroad, and it's in the system. So if you know there is such an issue, you should bring that all the documents related to the conviction or the arrest to your interview so that they can review it, and that could be cleared much more quickly. If you do receive a security check, you're supposed to give them at least 90 days for the security check to be processed. It's possible for attorneys to inquire through the National Visa Center as well. And the third way of doing it is, you can ask the congressional office where your hospital is located to intervene on your behalf and see why your security check is taking so long. One other issue, or a few more issues that can come up at the consulate, is PIMS. When you file for a petition-based case, such as an H-1B or an O-1, we always apply the petition in duplicate, because once USCIS approves it, they're supposed to forward a copy of the petition to the State Department, and then the State Department will scan in the petition into their system. And so when you go to the consulate with your approval notice, the consular officer will need to verify the validity of the petition within the PIMS system. And sometimes there's a delay in your petition being uploaded into the system, and so if it's not already there, the consular officer will need to request this to happen, and this could delay the issuance of the visa by a few days. And so that's the PIMS, but the one good thing about PIMS is that you actually don't need the original approval anymore. If you're abroad, your attorney or your employer can scan the approval notice to you, and you can just bring a copy or a PDF printout of the approval notice. You no longer need that original document. If you do have an issue at the interview, remember to when you go home to write down exactly what happened at the interview. You will receive a letter from the consular officer indicating what the issue was. If it's a 221G indication, that means that they're missing some information, and they will tell you exactly what it is that you need to submit to them. A 214B denial or issue is that they're not quite convinced that you're going to go home, that they think that you're going to, your intention is to remain in the United States permanently, and you haven't quite convinced them that you have sufficient ties to your home country and that you're going to return after you finish the purpose of your visit. And for that one, you should think about reapplying after a few months and gathering the additional information, and you can always request reconsideration. All right, so this is basically everything that I wanted to go over on this presentation. And these are some other issues that, I think we've gone over all of these, but if you have any questions, please do feel free to email them to me. And let me just see if I can open up some of the questions that have come up here. Okay, there was a question about how many VA waivers have been granted per year. I actually don't have that statistic, but I can certainly, if you email me and I can find that information, I'd be happy to share that with you. That might be something that perhaps the ECFMG would have record of. There's a question with regards to physicians who are, you know, require fear persecution because they're gay, and yes, that would definitely be a good persecution-based waiver application. When you do get a waiver application, this just takes care of that 2-year home residence requirement. You would still need to think about what happens after you get this waiver requirement, because you will, to stay in the United States, you would have to apply for a green card or another work visa. So you could get this persecution waiver granted and then consider applying for asylum as your pathway to getting a green card, or getting an H-1B through your employer once the persecution waiver is granted, or if you're married, you can apply for the green card based on marriage as well. I believe we will be sharing a copy of this presentation through our website, and there's somebody asked a question about coming to the U.S. on the tourist visa on a B1 to take an exam, and whether or not this would be considered misrepresentation to change status to J1. When you're coming for admission and you know the CBP officer asks you for the purpose of your visit, I think it is you should show that you've got you're going to be taking step 2 or step 3 exam, or you're coming for interview, and that's fine. But that is the purpose of your visit. It's not to change status. Once you've been here on the J1 and it's been a few months, later on it is possible to change your mind and apply for the J1, but you have to think about your timing as to when the application is filed. But if you are telling the CBP officer that the purpose of your visit is to take an exam, or to sit for the boards, or to go for an interview, those are fine. You should have be able to document all of that, and then it's best then that you go, when your J1 is issued, the DS 2019 is issued, you go home and you apply for the J1 visa. Simply, it's that it's better for you in the long term to be able to travel in the future, and because the training will take several years, and you want to be able to leave the country and visit your family if you can. How long does it take to process a Conrad State 30 waiver? It depends on the state. The typical schedule is that the program opens in October, and so you would try and apply through the month of October. The Department of Health will collect all the applications, and then we'll probably get back to you sometime around January, February, or March, once they've decided which of the applications they want to recommend. And then once you have the letter that the Department of Health will be recommending your application, it goes to the Department of State. The Department of State will then take another few weeks to review the application, and then finally they will then send their recommendation to USCIS. So in terms of timing, if this process starts about a year before you're finishing your residency or your fellowship. You should start looking at positions, I would say, maybe around July or August, the year before you graduate, so that your contract is signed and you have that 3-year agreement. Everything is collected and submitted to the Department of Health in the fall. You find out by the winter, January, February, March, whether or not it's been selected, and then assuming you are selected, the H-1B petition would be filed sometime in March or April with the July 1 start date, and then you finish your residency and you then transition to the H-1B for your Conrad waiver process. If in January or February you realize that you're not selected for the Conrad waiver, then you have to scramble and find out which states still have slots, and then look for another job and apply for you could try applying at a different Department of Health, and then you will probably need to do the start with the process again in terms of doing the DS 3035 and submit, and then eventually having it submitted to the Department of State. Okay, I think those were all of the questions that have been posed. If you have any, if you think of any other questions, please feel free to email me or to call me. My information is on the screen. So thank you so much.